Hello, 1836 clients and partners. Matt Leschber here, founder of 1836 Property Management. Today, I wanted to provide a quick update about regulations regarding evictions as we move toward the end of 2020. Please note that this is the most recent information we've researched and collected from local, state, and federal websites, from speaking to the Justice of the Peace Courts, as well as our on-retainer attorney. We are not licensed attorneys, so we recommend that if you have any issues that arise, you also consult a licensed attorney. Now, for the details. First, I'd like to mention the CARES Act, which officially expired at the end of July. This federal act suspended evictions through July 24th for residents living at certain properties, participating in federal programs, or with federally backed loans. As of July 25th, landlords at these covered properties may now begin the eviction process, but they have to provide a 30-day notice to vacate to their residents. After those 30 days, landlords can proceed with the normal eviction process. There is, however, a new CDC declaration regarding the spread of COVID-19 that has been introduced, which is required to be sent to all residents that have not paid rent. This states that they've made their best efforts to obtain assistance, make below a certain income annually, and if evicted, would become homeless. If this CDC declaration is returned at any time, an eviction may not be filed until after December 31st, 2020. While the federal act expired, state and local governments may also have their own regulations regarding evictions. The Texas Supreme Court, for example, has a requirement that any eviction filings through December 31st have an affidavit that is required to be filled out that certifies whether or not the property would have fallen under the CARES Act. Properties under this act require a 30-day notice to vacate be sent to the tenant. On the local level, if the property lies in Travis County or the City of Austin, no notices to vacate are permitted until after December 31st, and a 2-month notice of proposed eviction is also required through that date. After that 60-day notice has expired, then landlords can send a 3-day notice to vacate to residents. Only after that point can an eviction be filed for non-payment of rent. Regarding eviction regulations specific to Williamson and Hayes County, these counties are hearing cases, but it's still important to know if the property falls under the CARES Act. That same affidavit I mentioned previously is required still through December 31st. If the property is a covered dwelling, a 30-day notice to vacate is required. If not, a 3-day notice can be sent. Again, remember in all of these cases, if that previously mentioned CDC declaration is returned by a non-paying tenant, an eviction would not be possible to file until after December 31st. If you find all of this confusing and overwhelming, you are not alone. At 1836, we not only keep in constant contact with officials and trade groups, but have an attorney on retainer to ensure we're the best person to serve you and your clients. That sums up the information we have for you regarding eviction proceedings, federally and locally, which we understand to be true as of today. The regulations and dates change often, so if an issue arises for one of your clients, we recommend consulting federal and local websites with the Justice of Peace Courts, your trusted attorney on the matter, or simply referring those clients to the best property management company in Austin, Texas. Thank you for tuning in. Have a great day.